This afternoon, we're proud to present two attorneys on the front lines, Michael Bamberger and Rebecca Hughes Parker, both of the global law firm Dentons. Michael and Rebecca are on the legal team seeking to overturn the Arkansas law that allows criminal charges against librarians and booksellers for making available books that are, quote, harmful to minors, unquote. They will discuss the status of that case and other state laws that are resulting in book bans and legal threats to libraries. Michael Bamberger, senior counsel at Dentons, is one of the nation's leading First Amendment lawyers, having appeared before the Supreme Court and 9 federal courts of appeal. He is also general counsel to the Book Industry Study Group. Rebecca Hughes Parker, a Port resident and member of the FOL's board of directors, is an attorney in Dentons' litigation and dispute resolution practice with a focus on media, First Amendment, and data privacy and cybersecurity law. The current situation is, quite frankly, frightening. Restrictions first aimed at school libraries are increasingly targeting public libraries, where they could affect not only the children's section, but also the books available to everyone in the community. The American Library Association reports that from January through August of 2023, nearly 700 attempts were made to censor library materials, targeting more than 1,900 individual titles. Challenges to books in public libraries accounted for 49% of those documented, compared to 16% during the same period in 2022. Most of the challenged books were by or about people of color or LGBTQ people. This marks the highest number of reported attempts to remove library materials since the founding of the ALA's Office for Intellectual Freedom in 1967. Now to discuss this timely and important topic, I present attorneys Michael Bamberger and Rebecca Hughes Parker.
I will briefly put the censorship of libraries in a historical context. Then Rebecca will highlight what has been happening recently, including Arkansas, which she and I worked on trial. And then we will throw out some thoughts as to where we are going and what libraries can do. And finally, we will be happy to respond to any questions you all may have. The issue of libraries and censorship, unfortunately, has a long history, generally dealing with materials dealing with sex, violence, religion, and race. The argument is that there is a need to protect children and those less able to deal with what is sometimes called difficult materials and difficult arguments. In the 19th and early 20th century, material was available to the upper classes who could afford to buy books and restricted as to others. With the growth of the public library system, aided by Andrew Carnegie in this country and partly throughout the world, and the availability of movies, comics, and paperback books, and more recently by the internet and electronics transmissions, the issue has become more and more complex, both as to minors and as to the lesser educated. With respect to sex, which is what is usually the focus of recent censorship attempts, the Miller-Ginsburg test defines what material is not protected by the First Amendment. The First Amendment, I must add, is really at the core of what we are talking about. It is really the core of what protects not only libraries, but publishers and booksellers and authors and readers in this country. And what is interesting is some people say that the First Amendment The fact that the First Amendment is first shows that the importance that the founders gave to freedom of speech. Unfortunately, in the original proposal for the amendments, the First Amendment was not first, but a number of amendments which were listed ahead of it failed. But it's a good argument anyway. And the Miller-Ginsburg test, which I'll talk about more particularly in a moment, defines what is obscene and what is not protected by the First Amendment. And this is different from what people call porn or pornography, most of which is protected by the First Amendment, with the exception that it may not be protected vis-a-vis children, and particularly younger children. One of the interesting things is the Ginsburg case is a 1968 case about a luncheonette that's not far from here in Belmore. And the operator was charged with selling to a 16-year-old what was then referred to as girly magazines, which, to be frank, most people today would not be concerned with. And he was convicted under New York state law, and the case went up to the Supreme Court, and the Supreme Court said that you could have a different test for what can be banned as to children as opposed to what can be banned as to adults. And the test was later clarified in a case called Miller, which was not from this area, it was from Southern California. And the two together create what is the basic test that is applied in terms of banning materials, which is material is vis-a-vis children, and that's basically what we are talking about in the library context. Three questions. Number one, whether the material as a whole and taken as a whole is very important. You shouldn't be able to pick out one paragraph on page 192 and say, oh, it's a terrible book. But taken as a whole, whether the book appeals to the prurient interest, which means relating to sex. Number two, whether it patently offends the community standards with respect to what is appropriate to minors of a given maturity. And that means that you have a different test in one locale and then in a different locale, depending on what the local standards are. And finally, and this third part is particularly important vis-a-vis libraries, is the material cannot be banned if it has, taken as a whole, if it has serious literary, artistic, political, or scientific value to the minor. Now, that's very close to what guides librarians, from what I understand, in terms of choosing what is in a library. Now, people have asked in the past, what about material that is not serious but has real entertainment value? Some people have argued that that is a form of art, and generally the courts have accepted that.
Like comic books,
Like
we represent the comic book legal defense funds. That would be an example, maybe not serious, but some of them, but art, and we still use that argument.
Right. Now, current censorship attempts of libraries have been particularly focused on materials relating to LGBTQ, materials that deal with interpretations of history, and materials that deal with interpretation of science. Now, the law is clear that in protecting children, you cannot interfere with the access of adults to the material. Supreme Court has said this in a case called Ashcroft, where they said speech within the right of adults to hear may not be silenced completely in an attempt to shield children from it, which is to say that, for example, in a library context or in a bookstore context, you cannot be forced to eliminate material that is deemed not appropriate for a nine-year-old child, and simply say, okay, it's open to everybody, but there's none of this material can be available. And Rebecca's going to talk about some of the cases and how this applies to particular books. In terms of banning minors' access, many of the laws today try to prevent minors from browsing within a library material that is not meant to them, or that some people think should not be available to them. They have tried it in different ways. There was a law which was knocked down. In fact, we were involved in knocking it down, which imposed a 6-foot rule. It said that books not appropriate for children had to be on shelves more than 6 feet high. Now, you and I know that what that means is that short adults can't get the books and tall teenagers can. And it didn't make any sense and got thrown out. And in fact, a number of the library cases that Rebecca will shortly be talking about have said, well, you have to separate them in a way that minors have no access to them. And it simply doesn't work. It doesn't work in the small library context. It doesn't work in the larger one. So that this is basically what is going on today. And I leave it to Rebecca to talk about the specifics of what has been going on in the last couple of years and what we and others have been doing about it.
Thank you, Michael. I guess it was Michael who got rid of that 6-foot rule. I think he played a very, very big role in that case, and many others that the current victories, I think, owe a lot to Michael's, or almost everything, to Michael's cases that he's argued over the years. Are there any other cases that you want to talk about before I start?
No.
Or no, you're good. Okay.
Maybe I'll talk about one.
Yeah.
Which is not relevant to libraries specifically, but shows the complexity of issues. There was a number of years ago, and the years are getting longer, about 35 years ago, there was, in fact, she's still teaching, a law professor by the name of Catherine McKinnon, and she developed a theory that the reason that women are not getting their due in the employment field and in general society is because of pornography, because of, to use the words that she used, depiction of the subordination of women. And she and a poet by the name of Dworkin together created a law, and it got passed in the city of Indianapolis, and which said that if a book or artwork depicts women in a sexually subordinated role, that any woman suing on behalf of womanhood in general could sue to ban it. And the case went up to the Supreme Court. We won it in the trial court, we won it in the appellate court, we won it in the Supreme Court. And there was a wonderful brief written as a friend of the court by the ACLU, by a professor of intellectual history working with lawyers, that listed all the arts starting with the Romans and the Greeks and working their way up, that would be banned if you banned any artwork or written work which depicts women in a sexually subordinated role. But anyway, these concepts become tortured, if you will.
Yeah, I love that case because it does show you how it's not just one side politically or one side ideologically. When you ban books, you know, there's both sides, and so it's not always, you know, just one way. So I'm going to talk briefly about what's happening now in libraries, also bookstores, because we represent bookstores, including public libraries, and a bunch of laws that are being challenged or some struck down temporarily. And there is a push to have legislators and parents usurp the role of librarians and public librarians, school librarians, booksellers. And a lot of the laws have common themes. Some of them have all the themes, some of them have one of the themes. Some of the laws, and this relates to what Michael was talking about with the Miller-Ginsburg test, which is certainly a theme here, where the book will be harmful to minors if it's only one passage in it might be objectionable and doesn't look at the whole value of the work. Another one, which Michael also alluded to, is that there's no differentiation between a younger minor and a mature minor. So that's a big problem, and Michael has successfully argued that in other cases over the years to strike down these statutes where the law doesn't treat a first grader, second grader, let's say, any differently than an 11th grader. And we all know who have kids that you would think they have very different, you would want to give them very different kinds of books. And I'll get to it in a second, but in our case in Arkansas, the judge at the oral argument we had this summer was repeatedly bringing that up, that the legal age of marriage is 17. So you're telling me I can't give a book about sex to a 17-year-old, you know, because I can't give it to a 7-year-old. So that's another problem with a lot of these laws as well. Is that me? No, not us. It's not us. Another problem with the laws is that many of them are vague and hard to apply, so no one really knows what they mean. Some of them require the removal of books. Some require, as Michael said, restricting access to minors. Some there's a procedure. Some are just taken away. And so I'm going to mention Iowa, Florida, Texas, and then Arkansas. So a little bit of a tour around the country. And as Pam noted at the beginning, there's been a huge increase just in general of these of books being challenged and removed. I will mention one other Supreme Court case because it's a little legalistic, but it does form the basis for a lot of these decisions. Also, actually, originally from Long Island in the 80s, it's a case we call Pico v. Island Trees School District, which gives some guidance about school libraries from the Supreme Court of the United States. In that case, there was a plurality, meaning there was a lot of individual decisions and not a true majority. So it's not as strong as maybe some would like. But what it basically held was that school boards can remove books from libraries in certain circumstances if they're vulgar, if they're a suppression of ideas, but they cannot remove them because they disagree with the content of those books. And that's really important in a lot of these laws that we're seeing. You can't, look, if there's you don't like Trump and there's a book that is favorable about Trump, you can't remove that book because of that either. So, you can't, it goes all ways. So PICO is something that is relied upon a lot. Usually the people challenging the law rely upon it, and the people trying to uphold the law say it's not a strong case. Is that right, Michael? Is
Right.
that pretty much what happens in a lot of these cases? We can't rely on PICO, but I thought it was interesting because it was yet another Long Island case in Island Tree School District down in the South Shore in the early 80s. So in Iowa, and this is sort of hot off the presses because some of these decisions have come down in the last 2 weeks, I think, right? In Iowa federal court, a few groups such as and publishers such as Penguin House have sued the school board, the state, and also with some well-known authors, Laurie Halse Anderson, John Green, Jodi Picoult. They're all plaintiffs, meaning they're suing. There was a law that established a curriculum which only allows age-appropriate books from K through 12, and also doesn't allow the mention of sexual orientation or sexual identity through the 6th grade. That latter part actually covers basically through the 8th grade, because the school libraries, I'm told by the lawyers on this case, it's pretty much 6 through 8. So it basically extends it to 8th grade in a way, because it's the same library for 6 through 8 as here, where there's a middle school. So the school librarians, when this came down, anticipating what they'd have to remove, removed many, many books, from classics like Ulysses, Brave New World, to I Know Why the Caged Bird Sings, A Bluest Eye. I mean, Toni Morrison gets a lot of these. She's on the list all the time. The Fault in Our Stars, also some nonfiction books like The Truth About Rape and things like that. So there was tons of books removed, on both prongs of that law. And the law was set to go into effect on January 1st of this year. So these librarians were doing it in advance of that. But the plaintiffs in the case challenging the law sought what we call a preliminary injunction. What that means is that they are seeking temporarily to stop the law, to join the law, and they have to convince the court that they have a high likelihood to succeed on the merits of the case, so that the court will say, no, the law is not going to go into effect, and then we'll consider in a longer term a permanent injunction. So that was granted on January 10th, I think, around there. So very recently that was granted. So that law is temporarily stayed, those two parts of that law. And the court there, it's a district court, a federal court in Iowa, so not yet at the appeals level, but in southern Iowa, said that the students had a constitutional right to receive information from their libraries. And they used that case, PICO, I talked about before, and the court said you can't have a pile of orthodoxy over the classroom. And also cited the vagueness and overbreadth of the law. We often argue that these laws are overbroad and affect way more people than they're meant to. In this case, the way the law was drafted, and some of these laws are not drafted that well, this law, when it said you can't talk about sexual orientation, actually would include, the plaintiffs argued, any relationship whatsoever, homosexual, heterosexual. You couldn't talk about children. You couldn't talk about zoo family, like animal families. So the judge agreed with the plaintiffs in that case and said, this is ridiculous. You can't talk about anything if we were to follow this law. And so the judge struck it down temporarily for the moment. So it's not in effect. The governor of Iowa, Kim Reynolds, said, standing by the law, she said, there's no question that books containing sexually explicit content do not belong in a school library for children. The fact that we're even arguing these issues is ridiculous. And I think she said that even before the decision came down. She had a couple of statements like that. And the plaintiffs in that case, the people challenging the books, argued that those kinds of statements actually stigmatized the books even more, and there's an economic effect there for the authors. Michael and I represent the Authors Guild, so it affects the author's ability to sell books when all of a sudden their books are labeled pornographic or sexually explicit, all of them. So the plaintiffs use that. And again, the test is not following, this law is not following the Supreme Court's test, which it laid out in Miller-Ginsburg, those cases. So a fun fact about this law that I know Michael likes a lot.
Yeah.
You want to say your favorite part about this decision?
My favorite part about this law is this law says that not covered by the law is the Bible and the Quran, which means that they realize that the way they defined sexual act would even cover banning the Bible and the Quran, as well as everything else. And
Yeah.
the court mentioned that in a light moment going through a lengthy opinion.
Yeah. I like that the plaintiffs in that case argued that the law, which it's based on, which describes what they're outlining, is actually more explicit in its description of sexual acts than many of the books that have been banned. So, and they use some passages, single passages in books, which is why the books are removed or, potentially banned, are not explicit at all. But if you go to the law book, which ostensibly anyone could get if they really wanted, you would see more explicit description. Kind of, yeah, like the Bible.
Yeah, and it's the vagueness, the real danger of the vagueness is, and it'll come in the other cases that Rebecca's talking about as well, is the fear that it puts into librarians, or booksellers or authors, but particularly booksellers and librarians, because they're at the front lines, in that they have to make a decision. Is somebody going to say that I violated the law, which in some jurisdiction is a felony, or shall I remove a book that I think is perfectly good, maybe valuable, and so on? And this is an intolerable situation for library staff, library boards, etc.
Yeah, and that case, so Iowa's in what we call the Eighth Circuit, which the appellate courts the appeals courts are divided into circuits. So that will go. It already has been appealed, right? Their notice is already to the Eighth Circuit for that appeals court to look at that decision and see what they think. I don't think we know really what the Eighth Circuit will do, because when I get to our case, Arkansas is also in the Eighth Circuit. So we're not sure what the Eighth Circuit will do. Certainly the circuits around the country have different leanings, and depending on the panel of judges you get, there's different leanings. But I'll move over to Texas, which is in the Fifth Circuit. And there's a case in Llano County, Texas. And this actually started 2 years ago when members of the community complained about certain titles were inappropriate for children. The libraries in Llano County actually shut down for a few days to review all these books. The library board, which governed Llano County, was replaced by all these people who were in support of banning these books. So there was a whole overhaul of the library board. Books that were originally removed, Maurice Sendak's In the Night Kitchen, Susan Campbell Bertoletti's They Called Themselves the KKK, Jazz Jennings' book. They are actually, what the defendants there argue is they're actually behind the counter, which is one way to, I guess, remove them from minors. I think Michael and I would argue that this unconstitutionally burdens many more people than just minors, but that's what the defendants argue there.
Besides, you need a big counter.
You need a lot of space. In that case, the preliminary injunction, I mentioned that before, when you try to stop the law temporarily, that was granted. So it's not that those rules are not in effect right now. But there's a lot of things going on in Llano County, Texas. the original librarian, one of the librarians, asked to hide the books or move them over, wouldn't do it. She lost her job because of that, we're told, by some people on the ground there. The appeal was heard earlier this year in the Fifth Circuit Court of Appeals, but there's been no decision yet. The state there, the county there, the government there is arguing that there's not a real injury to anyone because they can still get the books. And they say that this is not, it's not viewpoint discrimination, which is why I mentioned Pico v. Island Trees earlier. This is not that. This is just normal weeding. And I think librarians would be familiar with weeding of books, which is a common practice that they do because you can't have every book in the world in your library all the time. So that's what the state is arguing. And we don't know how that's going to come out yet. It was a couple months ago, so I would think soon, probably. One of the judges at the oral argument, asked the plaintiffs, the people challenging the law, would you remove white supremacist David Duke's autobiography? And they said, yes, we would. We would not remove it. We would keep it. We would have it in the library because, we don't agree with that viewpoint, but we can't remove it because we don't agree with the viewpoint. So that's just a taste of what that oral argument was like. So we'll see what happens there. Also in Texas, we have a case which is a very interesting one. And this week we got a decision from like 3 days ago, I think. Yeah. We got a decision in the Fifth Circuit affirming an injunction, meaning that the law is not in effect. This law is called the Reader Act. I think legislators like to use acronyms that they think mean something. This is, the plaintiffs argue, is not good for readers, very bad for readers. It forces vendors and publishers of books to rate their books as sexually explicit or sexually relevant if they want to sell to a school district. And school districts can't purchase sexually explicit materials, and they cannot have students check out sexually relevant books without their parents' permission. And vendors have to do the work of recalling all previously sold sexually explicit materials. So they have to be reviewed every 2 years. Vendors have to publish a report. It's a whole. They also would apply to classroom libraries as well.
Yeah, and one of the important things is sexually explicit does not have the normal meaning that you and I would give that. It's once again covers one or more isolated examples of descriptions or depictions of sexual acts, and where it hits books most are in the descriptions of sexual acts.
Right, it doesn't follow the Miller-Ginsburg test, which was what was argued at the Fifth Circuit argument, and they did just recently win that one. And the judges on the district court level, I mean the court below, in finding for the challengers to this law, talked about the vagueness of it, and also talked about the compelled speech, because the First Amendment means you can't compel speech, and here they're compelling the book publishers to rate their books. The appellate court, the Fifth Circuit, focused mainly on that compelled speech argument, not as much that the law was vague. The challengers to this book, colleagues of ours, argued a lot about the vagueness of this law. I mean, what if two vendors in the same book rated differently? What would happen then? There's a lot of unanswered questions in this law, but the court in the Fifth Circuit really focused that you can't compel speech. You can't make the vendor say these things about its own book. So that some people disagree with that. I think even who generally agree with generally who don't like book bans do agree, right, Mike, with that compelled speech argument that the defendants made.
The comparison is if you were forced to put on a food or drug, this contains this and that, which may be harmful or whatever, even if the maker believes it not to be significantly harmful.
Right.
that comparison can be applied by some to the labeling of books. Though one of the problems with the reader is if the bookseller or the publisher gives a rating to a book and the state disagrees, the state can force the publisher or the bookseller to restate the rating the way the state wants it, which certainly is compelled speech.
Right. And the plaintiffs in that case are a lot of publishers, obviously, the American Association of Publishers, because this is really making life very difficult for them in Texas. Although right now the law is not in effect, so as of January 10th. So we'll see what happens next. Right. What do you think will happen next there in that case? They will try to get a permanent injunction.
Yeah.
Yeah.
Probably.
So now we'll move to Florida, which is always a hotbed of this. I don't think we've been to Florida. We haven't talked about Florida yet. So there's a case. There's actually a lot of cases in Florida, but a big one, also very recent decision. It was a case brought by a group called PEN America, which is a free speech group, Penguin Books, and 5 authors, 2 students. It was based on, again, books in school libraries that were restricted because of the, or actually I think they were removed while they were reviewed, which who knows how long that will take, because the school board asked them to. That started happening in July, I think, yeah, and the state moved to dismiss, meaning get rid of the whole case. Then just the last 2 weeks, the judge in the district court there denied the motion to dismiss and said, no, the case must keep on going because he said the challengers, the plaintiffs, have made a very good case that, or at least made out a case at this point that this is in violation of the First Amendment. And the same day that came down, over 1,600 books were pulled from the library shelves in Florida, including 5 dictionaries and 2 encyclopedias. So that law is actually, people are very, very scared of it. But actually, one librarian was responsible for hundreds of these challenges. So some of these are pretty centralized. There's one woman whose name is behind many of these books. But the court there, I like the quote. It said the court there held that the government speech argument that the government was making was inconsistent with the traditional purpose of a library, which is to provide information on a broad range of subjects and viewpoints. School officials cannot remove books solely because they disagree with the views expressed in the books, but they can make content-based decisions based on legitimate pedagogical concerns. And then the court held that the plaintiffs had plausibly alleged that defendants' removals and restrictions do not pass constitutional muster under that standard because the decisions were based on ideological objections to the book's content or disagreement with their messages or their themes rather than for pedagogical reasons. So I think that harkens back to the Pico case. You can't just remove the books because you don't like them. There's similar cases in Florida like this. One is only based about this book, and Tango Makes 2. Tango Makes 3, not 2. If you guys have heard of this book, it's about penguins, and there's 2 fathers, and it was banned in Lake County, Florida, and there's a lawsuit over there.
Which is based on a true fact story of 2 penguins in the Bronx Zoo.
Right.
2 male penguins who adopted a baby when the mother died.
Yeah. And one thing interesting about Florida is right now in the legislature in Florida, there's a bill that, because they've had so many book challenges in Florida, they are trying to charge people $100 if they want to challenge 5 or more books because they can't handle, even the Republican-controlled legislature cannot handle this many book challenges. It's an administrative burden at this point. So they're trying to charge people $100. And one thing I like about that is something we just read the other day. Even conservative pundit Bill O'Reilly derided The law, after school officials in Escambia County, that's the case I was just talking about, removed 2 of his books, Killing Jesus, A History, and Killing Reagan, The Violent Assault That Changed the Presidency, pending a review for possible sexual conduct. O'Reilly told Newsweek he implored the state and Governor Ron DeSantis to take action because this policy is far too nebulous in Tallahassee and needs to be tightened up. So, the law is so vague that it's catching a lot of people in its net, and it's not, not just one kind of book. It's catching Bill O'Reilly's books. It's catching the dictionary. It would have caught the Bible, maybe, if read literally. So that case has a lot of the elements in it. Vagueness, doesn't follow Miller Ginsburg. It's all fun in Florida right now. But we do know the lawyers in the Escambia case who are arguing, who are continuing to argue that case to try to get that law enjoined in Escambia County. So now I think we can go on to our favorite case, which is in Arkansas. Right? Our favorite current. Michael has so many cases. I don't know. The 6-foot one might be his favorite case, but one of our favorite cases. So Michael actually argued a case in Arkansas about 20 years ago, 2003 law, I think.
Yeah.
Do you want to mention what that said?
Well, it was a library and bookstore access case, trying to limiting access, and the case went to the Supreme Court of Arkansas, and the Supreme Court said that the law is meant to apply to all ages, and therefore you have to prohibit access to books that are not appropriate to younger children, even though they may be appropriate to older, and throughout the law. And then lo and behold, 19 years later, basically Arkansas passed the same law.
Well, it was both Huckabee, both Huckabees, right? Governor Huckabee and then his daughter.
Yeah.
Yeah.
And they passed it again, though part of a broader library challenge reorganization. And
yeah, they passed it again, and the culture is a little different now than 20 years ago. So as Michael said, as the culture changes, these kinds of laws change. I know Michael did a lot of laws against internet filtering when the internet first came out, and everyone was scared of what people would see on the internet. Right? There was cases against New Hampshire, right, Massachusetts,
right. And as a matter of fact, the courts correctly found out, because that's what the experts testified. There's no way that you can develop a filter that says this is appropriate for an 11-year-old, or this is not appropriate for an 11-year-old, but isn't appropriate for a 70-year-old, leaving aside, as those of us who have children and grandchildren know, that all 11-year-olds are not alike. But anyway, those are going on. Those are not generally library laws.
Right. Those are going on also age-appropriate design laws in the Supreme Court of the United States. But this Arkansas law, the new law passed, was supposed to go into effect August 1st, 2023. It's not in effect, which because of our case. We challenged, our clients are the American Booksellers Association, the Authors Guild, the Comic Book Legal Defense Fund, the Association of American Publishers, two Arkansas booksellers, and the Freedom to Read Foundation, which is part of, related to the American Library Association. So, and then we sued with a lot of other plaintiffs, mostly based in Arkansas, so we have a lot of great co-counsel. We challenged 2 parts of this law. The first part made it a crime, so a misdemeanor, which could be a year in jail, for anyone, librarians, booksellers, technically even parents, to allow minors to have access to a book that's harmful to the minor. This law actually does cite the Miller-Ginsburg test. It does use those 3 prongs that Michael talked about before, but it doesn't, we argued, it doesn't distinguish between your 10-year-old and your 17-year-old, and poses an unconstitutional burden on adults and older minors. And it's a crime, and it's very similar to the law that Michael already had struck down. Another part of the law that we challenged relates specifically to libraries. And the plaintiffs include the Central Arkansas Library System. A lot of libraries in Arkansas joined on this case. And there is a procedure for challenging inappropriate, and that's the word they use, inappropriate, so there's no reference there to any kind of formal test. This is a challenge procedure. So this is what the procedure is. There's an informal meeting between the challenger and the library staff. The challenger can submit a formal challenge, and the committee, a committee of library employees will look at that. There's no criteria, there's no definition of appropriateness. The challenger can present his or her case against the book in person, but there's no provision there for anyone defending the book. I mean, the book, the book itself doesn't get a defense. And I guess there's no constitutional right for the book to get a defense. There's no, but there is, we think, a due process, we argued, a due process problem here. And the committee would vote to determine if the book should be put in an adults-only section of the library, not accessible to minors. And if that does happen, there'd be no appeal, you'd be ending there. If that doesn't happen, and the library committee says, no, this book is fine, I'm just gonna put it wherever I wanna put it, a local governing body, and in Arkansas, these are called quorum courts, mostly, or there could be a city council, depending on where you are. They can hear the case, but there's no public hearing, there's no written decision that we can look at, they just hear the case there. And so that's the procedure that we challenged, and our co-counsel really, who represent the libraries, challenged, and we won. And the decision that I think you guys have that was handed out is part of that, the decision that we got from the district court judge in the summer. And we argued for our clients that for a bookseller, for a library, to create a separate room, how could they possibly comply with this? Creating a separate room would be prohibitively expensive. If you don't want to, if you're a bookseller but you want to sell all kinds of books, you don't want to label yourself an adults-only bookstore, probably. that might have a different connotation than you want. So we listed all these ways that made any of the choices that a bookseller or a library would have to comply with this law, the first part of this law, would just be untenable, right?
Yeah.
There's just no way they could apply. They would have to buy more space. They would hire someone to guard these books. Like, there's just no way that they could do it. And on top of that, of course, it's unconstitutional. It unconstitutionally burdens adults and older minors who have the constitutional right to look at these books. And what if you come in with your kid? You know, what do you do then? You know, there's all these questions that we brought up, and the judge agreed with us in kind of sweeping language, going through. We didn't expect this, I will say, the history of the library, basically starting with a quote from, Andrew Carnegie in our decision. So just parts of it, he said, for more than a century, librarians have curated the collections of public libraries to serve diverse viewpoints, helped high school students with their term papers, made recommendations to book clubs, tracked down obscure books for those devoted to obscure pastimes, and mesmerized roomfuls of children with animated storytelling. And he asks why there is such a newfound suspicion of libraries in particular. And he says, the vocation of a librarian requires a commitment to freedom of speech and the celebration of diverse viewpoints, unlike that found in any other profession. The librarian curates the collection of reading materials for an entire community, and in doing so, he or she reinforces the bedrock principles in which this country was founded. So there was some very broad language here by this judge striking down this law for most of the reasons that we argued. And so that law currently is, both parts of that law, both the part that makes selling or making available to a minor a book that is harmful to minors, a misdemeanor that is not in effect right now temporarily, and the part about the procedure for a library challenge is also not in effect right now temporarily. There was not an appeal, and this is the 8th Circuit, as I mentioned before, Arkansas is in the 8th Circuit. There's not an appeal right now, which means we're going through what lawyers call discovery, meaning we're getting documents and other facts about the case before we can make a summary judgment argument, which is basically a similar argument, I guess, to what we already made with some more facts involved. And that will be, again, in front of the same judge in the district court. Yeah, you want to add to the Arkansas case?
No, I mean, it's an important case. I mean, number one, it's obviously important to the people who live in the state of Arkansas, but it's also important because here's a judge who really understands the role of libraries and librarians and the issues, and we expect that fingers crossed, that this will move ahead positively, and then it goes up on appeal. But in the meantime, booksellers and libraries are in a position to do what they do and hopefully do it well.
Yeah, and like I said, at the oral argument, the judge was very focused on how could you restrict books for 16, 17-year-olds the same way you would restrict them for 7, 8-year-olds. And he asked the state about what does it mean to make available, because the law uses those words. There really wasn't an answer, I think, to that question. We don't really know what make available means, which is one reason it's so hard to comply with this law. So we'll see what happens there, but that's currently, so that's a little bit of a tour around the country of some things happening. There are many other things happening, but we'd be here forever.
So now, before we have the questions, just let us very briefly, I mean, we're not in the business of prognostication, which is a good thing. But where are we going? And something I think we can add a little bit to, what should library boards and libraries do in terms of present themselves well in this context? I would talk, and then Rebecca can add two things. Number one is you should, if you have not looked at your policies, not you, that a library board / library has not recently looked at its policies vis-a-vis challenging choice of books, because people are challenging, always have challenged, and will continue to do so. Make sure, A, that the policies are clear, B, that the policies are workable, and C, that you actually apply them. I mean, having wonderful policies that you can whip out is fine, but if you have a challenge by a challenger who is unhappy, to have a policy that is not quite what you do, you should either change what you do or change the policy to reflect what is actually done. And number two, highlight, both in terms of speaking to your community and speaking to your staff, the importance of the role of the library and the librarian in making available a broad range of materials rather than just the materials that make everybody happy.
Yeah.
Rebecca?
Yeah, I agree with the second point, because I always think, part of the, if you're, part of the beauty of the First Amendment is that, if you're, it has to include speech that you're offended by as well as speech that you like. And if it's only speech that you like, I think there's a problem there. And also adding to the first part about the policies, they should have mechanisms in there that are efficient and quick, because these things can move very quickly, I think, to the county government, to the state government, with some speed. So sometimes there's not a lot of time before books are removed and not available.
Okay. Questions,
Well,
either online or from people here? There's a microphone going around.
just need the mic on.
Good.
There we go. Before we take some questions, let's just have a round of applause for Michael Bamberger, Rebecca Hughes Parker. So I did see some hands. We'll start to go around. We'll also take some questions from those on Zoom. I'll be right back.
Thank you. Thank you for your talk.
Your mic is not on.
These boards and states, these boards and states that try to make these conservative book bans are going to get smarter. They're going to learn from your successes to write tighter rules. Is this going to get nastier and nastier?
Well, sometimes they don't learn, right, Michael?
Yeah,
'Cause you're-
I was going to say, having done this for 50 years now, I mean, there are various things. The battlefield changes from time to time, to the extent that the laws are written in a more appropriate way. Maybe they are right. I mean, it used to be that people who challenged books, depending on the board, either were laughed off or else basically automatically passed. That's not good either. Clearly, in the divisive time that we live in 2024, matters are getting nasty. School board elections are getting more vehement and at the same time more expensive. School board, library board, whatever the controls. The answer is I don't know. Will censorship go away? No. I mean, I can. There was censorship of Plato, which had nothing to do with the internet or LGBT or anything like that, obviously. But it's hard to say. What do you say?
I mean, I would think, as you say, that they would learn, because in a lot of other areas of law that I practice in, on the defense side, the plaintiffs learn, how to write a better complaint to try to get their relief, because the defendants keep winning and poking the holes in the complaints. So they learn how to write it better, and then it gets harder for the defendants to win because the complaint is tighter. In this area of the law, I'm not sure, because as we said, Michael fought a law in 2004 successfully that they seem to have repeated, not in whole, but at least in part, in 2023. So I'm not, and I think that might be because, we're dealing here with legislatures that have a lot of political pressures from their base. So I think it might not be as we would expect that they would write better laws, like the Iowa law. The Iowa law, which was completely vague, and the judge said, "How could you possibly, how could anyone possibly understand how to comply with this law when you can't mention any kind of sexual orientation? You can't talk about your husband or your wife or your kids, or it didn't make any sense." So those things, I guess, still are a little surprising, and maybe they're not getting better.
Part of the political situation today, or at least it's been this way for at least 20 years, is someone will put in this kind of a law, generally badly written, generally vaguely written. It is very hard, by the way, to write good, precise laws, and there are people who do that as a profession. But what happens then politically is his fellows look at it and say, well, there's a problem. But on the other hand, if I try to amend the law, to carve it, to make it narrower, to make it more likely to be constitutionally acceptable, I'm going to find somebody in my next primary who's going to say, Joe Blow tried to let in more porn by restricting the law. And that's from the point of view of a lawyer who's spent much of his life knocking down these laws. You know, that's good for me. But it's not good for society, because the time and effort that is spent in litigating this material and worrying about it is time and money that could be better spent.
But also, I'll just add quickly that some laws that you fought have been narrowed by the Attorney General of the state to be constitutional. So, you know, like, was it Virginia?
Yeah.
Was narrowed so that the Attorney General said that it would only be enforced if it was not appropriate or harmful to just the oldest set of minors, right? So just the 16, 17-year-olds. So when the Attorney General did that, the law was then constitutional.
Yeah, though that's not a good result, because it means that, you know, 10-year-olds may be getting material that is not appropriate for them, and the parents are going to have to deal with that when the kids come home.
We have another question right over here.
Thank you for your important talk, and thank you, Port Washington FOL, for bringing this to the fore, because it's in our backyard. So I really appreciate that. But my question is, I'm looking for comfort here. I'm not that, and I don't even know if this is a fair question. I don't have much faith in state legislatures, but I do have faith in the courts. And my question to you, and this may be anecdotal, do you feel, because it's being brought to the federal court, that they are not ideological as we hear about? That's a concern for me. I mean, legislatures are legislatures, but the courts are the courts. And my concern is that the courts are perhaps becoming more ideological, and that is troubling. Have you seen that in your travels? Or is that not a fair question?
There are judges that I'm not excited about. But I must say that the majority of courts that I have been before, irrespective of, federal courts, and there are some good state courts, but it's the quality. I mean, my late wife was a New York State Supreme Court justice, so I shouldn't say bad things about.
But she was one of the good ones. So.
Yeah, she was fine. But the federal court system still basically works and works well, and has conscientious people who have different views.
Yeah, I agree. I think most of as you're referring to checks and balances, and yes, I think that most of the federal courts, no matter which president appointed them by, before you argue a case, you're always looking, who appointed this person? What's their history? But yeah, I think most of them are pretty good and pretty reasoned, and they're worried about being struck down by the court above them, and ultimately the Supreme Court of the United States for some of these cases. So they do think about that, and if you deviate too much from precedent, you're at risk of being overturned, and no judge wants to be overturned, right, Michael?
So we're going to take another question here, and then we'll check in on Zoom.
I think we all would feel better if it wasn't for the current Supreme Court. So where does this all happen with the strict constructionists majority that's currently on the court?
Well, strict construction, you had Justice Hugo Black, who goes back to the 40s, who was sort of one of the original strict strict constructionist, and his view of the First Amendment was really strict, which is that when the Supreme Court, when the Constitution says no law, it means no law shall, restrict speech. That doesn't really work perfectly either. The Supreme Court has really not decided for a long time
Yeah.
cases in this area, partly because, I believe it was Justice Stewart who said, I don't know how to say it, but I know what's obscene when I look at it.
Right. I think it was.
That's a bad paraphrase. He spoke much more coherently.
I know it when I see it. Yeah. Yeah.
But the answer is, I'm not so sure that I want to be the first person that takes one of these cases to the Supreme Court. And
To this Supreme Court, because you have in the past, but to this
to
one.
this Supreme Court,
Right.
I've been in the Supreme Court before with success. But the answer is I don't know. And by the way, Cross, one of the strong supporters of the First Amendment was my law school classmate, Justice Scalia, who on virtually everything else was very conservative.
And sometimes, like the 303 creative case, you guys, that was the case about the baker of the cake for the lesbian couple. That is used by different sides doing different things. That's about compelled government speech. So if maybe if you're talking about the Texas book rating case, you might use that case, which some might call a conservative case, but you might say, no, you can't compel my speech. So, sometimes cases in this area aren't as exactly as they appear at first.
Right.
Hold on, let's get.
How have the ratings in the movies survived if you're saying that, ratings are bad? I know they're not government run.
No, the MPA, the distinction that the motion producers make is that theirs is a voluntary rating system, the same way the old comic book rating, which I must say it's been a while since I last looked at a comic book, but I don't think they use them anymore, was also a voluntary, and in fact attempts by various states to incorporate the motion picture rating system into criminal state laws have been opposed by the MPA.
Okay, another question here, and then we'll go to Zoom.
Hi. I wanted to know, okay.
Okay.
I wanted to know why you feel that we've suddenly been hit with this epidemic to restrict human rights and interfere with the flow of honest communication and the flow of honest facts.
It's a broad question.
Well, let me give my view. Two things. Number one, in the area, in certain areas, there are disagreements vis-a-vis facts, certainly in the historical and racial areas. But more important, there have been cultural movements which are not unique to this period that have said that certain things are just morally wrong. And and should not be permitted. And that is being fought out in all kinds of arenas. But one obvious one is the library context. What do you think?
I don't know. Yeah, I think there's definitely been more book restrictions as we've talked about. But I don't know if it's a new idea. Certainly as your cases have demonstrated over the years, to restrict the flow of information, it just shifts, to what the cultural milieu is at the time. So I think this is just how it's manifesting itself right now. Certainly, I mean, look at, there's been many instances in modern history where there's been a lot of censorship, right? I mean, that you've lived through.
Yeah, and I think part of it is that people have not in the past focused on the ability, or certainly not to the extent they are today, the ability to use political means to impose guidelines that they favor on schools and libraries. I mean, school board elections, and I live in Manhattan, community school boards and so on. Sure, there were people with different views, but the cultural issues were not brought to those boards. It has now been demonstrated that there is a political ability to raise some of these issues that were not raised politically. Rather than by going to librarian school, you simply do a campaign to get on a library board.
I'm going to check in upstairs. I think we have some questions up there.
We do, Jeff. This one is there someone representing the Port Washington Library that can share with us the library's procedures on a patron wanting the library to ban a book? Or can a resident read that policy? And if so, where?
I don't know.
Want me to take a swing at that, or
Jeff? Yeah.
Bill Keller? I don't know if you as
Bill?
Board of Trustees. We do have a policy. I think it is available for the public to read. And I think the library board has even recently reviewed that policy as well.
I'm Bill Keller. I'm the president of the library board. We have reviewed it recently, partly because these issues came up again, and I think it was Island Trees, right? Suffolk County, there were book bans were done like in the heat of the night, and when the word got out, everybody rose up and they overturned it, but it did send chills through our spine. You also might know that Great Neck a year or two ago had an incredibly controversial library board election where actually somebody spent $90,000 to fight the battle. So it is local, and we have gone over the procedures. I think they meet everything that Michael suggested, and they are accessible either online or certainly if you ask at the library.
Thank you, Bill. Did you have another question upstairs?
Yes. How much dark money is behind book banning?
How much dark money is behind book banning? I don't think we know the answer to that.
From my view, it's pretty cheap to do it.
Yeah, I agree.
I mean, it's dedicated people. I mean, there's a guy in Texas who has put up I believe the number is 1,076 books that he asked his local library to pull. Now, obviously, the burden on the library staff is vast, and what it does in effect, particularly if you have a policy that says anything challenged automatically gets pulled off, what it means is that you have months and months of books having been pulled, quote, temporarily, while someone sits through, or someone's plural, sits through and reads them all.
Right, and the obvious point is that the state entities are defending these cases, so that's taxpayer money, not private. Although I guess in our case, the Crawford County has its own law firm, right? But but they're being paid by the taxpayers.
Yeah.
So to defend these cases is tax money.
So one question I do have for you guys, maybe you can comment on in terms of just some of the chilling effect of these book challenges. I believe the last 3 or 4 months, the Scholastic Book Company was faced with having to make some decisions about the upcoming school year and how their scholastic book fairs would be held in schools. They were trying to make a decision that would fit all of the states that they operate in all at once. And they were going to have a separate section for certain books as well as their general selection of books. Scholastic did end up reversing their decision to have these separate zones at their book fairs. Their intention was to protect the teachers from legal trouble. But obviously this had a chilling effect on Scholastic Book. Could you guys comment a little bit about that in terms of how this is affecting publishers and others involved?
Yeah, I mean, I didn't mention the Crawford County case itself. There's a parallel case to ours in Arkansas, which is affecting ours, that's based in a county called Crawford County, because that library system actually made, I think in anticipation, right, of our law that we struck down, or that we temporarily struck down, relocated its many books to something called the social section. So many books about history, race, but not just LGBTQ, but many other things too. And there's a lawsuit about that, so patrons sued there as well, arguing that it's a stigma, it's chilling speech, like you said. I believe that preliminary injunction didn't work, so that right, I think the social section's still there, and we also sued our clients also sued Crawford County, so they're also a defendant in our case as well. And actually, in there, a librarian refused to do that, and she resigned, and they gave her severance pay, and it was under investigation why they did that. But there's some kind of scandal that, going on. So there's certainly a lot of repercussions to that. But the argument about separating books into a social section, the authors have made that too, that stigmatizes their books. Maybe not even the one book that was put into the social section or put in an area inaccessible to minors, but other books that they have written, would kind of bleed onto those books and affect their economic livelihood. And that's something we've argued for the Authors Guild, the Association of American Publishers, that kind of stigmatization. Right, Mike?
Yeah, I mean, you have a problem, not a problem. The United States is large. There are many governmental agencies and so on. For years, for example, I'll give two examples. For years, Texas had an organization, which they may or may not still have, which basically authorized books for schools. And they had a unique approach. And therefore, both with respect to evolution and abortion and various other things, and given the size of the Texas book market, that clearly influenced publishers on a monetary sense, not even chilling throughout the world. One other thing, I don't know that Port Washington subscribes, but there are various agencies that provide libraries with thousands of ebooks, right? And some states, some jurisdictions have gone to them and said, we want you to leave out books about this and books about that. And they have said, no, we really can't. I mean, it would be impossible. It wouldn't be impossible. It would be difficult and wildly costly. And therefore, some jurisdictions have pulled out of those systems, which particularly if a library system has significant members or whatever you call people that take books from
Patrons?
Pardon?
Patrons?
Patrons, thank you, better. Have patrons who are homebound. They were suddenly cut out from this significant resource. So there's a lot going on, and we thank you for your interest.
Okay, we have one last question.
Thank you. Hi. So we're all school librarians in high school in New York City. And one of the things when we have a book challenge is there's procedure. So one of the requirements, the first is have you read the entire book? And you're talking about the Port Washington policy. You mentioned Arkansas. You mentioned someone in Texas who challenged 1,000 or more books. Is there a requirement, can we make it part of policy, that you have to read the whole book before you challenge it and not just challenge a section of a book that, or a word that's made its way through the internet or Instagram to these specific groups?
Yeah, I did wonder the same thing when it was a woman, I think, of Florida who challenged many hundreds of books if she had actually read the whole book, given that the correct constitutional test would, you have to take the book as a whole and look at its literary value. So
Yeah, it's most policies do not include that, which shifts the burden to the library. People have said in arguments that I have been in, have said, boy, I read pages 10 through 17 and I couldn't stomach going beyond it. Now I could say that about perfectly good books as well. But it's difficult, and we laugh at Florida's putting a cost on it, but the people who bring in 100 books which they haven't read, or the names of 100 books that they haven't read, but they found it on a list that some other person in a different state made, just really is not fair in terms of the imposition on the public entity.
Well, I want to thank you both very, very much for being here. Let's have a round of applause. I certainly appreciate that we've been able to hold this in a library. I want to thank our wonderful friends of the library for helping make this program possible. Thank you all for being here. Thank you for your time, your considerate questions, and I will wrap things up. Thank you so much for being here.